let's look at the lesson in your book, starting on page 116. System. Okay, what I'd like you to do to start with, this is easy. You can do this in groups, you can do it on your own, you can do whatever you'd like. I'd like you to read the essay, and as you can tell, this is another one of those essays, 2 pages, 1 page front and back. Read the essay, and then look at handout A, which is selected Fourth Amendment Supreme Court decisions. So read the essay, looking at handout A, and then we're going to discuss that, both the essay and the handout. Okay? So take a little time now. You can talk to each other if you want. You can do this individually if you like. The only thing I ask is, if you're going to snore, please snore quietly so the people next to you don't hear you. It's the death hour. If I could, I'd make you stand up here. Speaking of the death hour, if you're still hungry, there are sandwiches up here, and there's a fresh pot of coffee. So. Okay. What we want to do is, again, as you worked with that essay and that handout, is there anything that struck you besides the fact that, first of all, the essay is trying to get a very complex idea over in a very clear and concise way without really spending a lot of time on exceptions? And I was reading and I thought, this is Art's entire lecture reduced to an 8th grader. Without all the case names. And because it was the same ideas, wasn't it? It's what we just heard. Dr. Ward, it's the same information, just reduced down to a smaller level. How does the handout help with this? Did you use the handout?
I think you have to question as an educator of, is this one damn case after another?
Right.
Or do I want to go in depth with one case, or are we trying to show so many different types of variations that it's important to do? So you have lots of options, I think, of which way to approach it.
Okay, so this is one of those things where you can make a decision based on, I just want to focus on the idea, and then I'll focus on the exceptions as I move forward, or should I just present it all as a whole and use the idea of incorporation, use this idea of the Supreme Court's involvement in this area of protecting individual rights being protected? Should I bring it in that way, or should I bring it in sections, right? We can do it either way. But giving you all the cases does what? I mean, what was the whole point of doing that besides the fact that hopefully they can succeed? The cases are listed in the order they show up in the reading, right? So this isn't one of those things where they could get confused because they thought they skipped one because they didn't, but they didn't realize that not everything is in order. Life is inherently messy. Okay? Yes?
I was just going to say, I think it also focuses on two important issues that in some way will affect or know about these students. I mean, privacy and technology, and of course, drug testing.
Right.
Something that has always been discussed.
And we bring it back to the students and that thing, right? We bring it back to the drug testing, we bring it back with those reasonable expectations in a school building. Again, tie it back to the kids as much as you can is a good thing. The focus of this, by having them do this, besides hopefully that they succeed and they can actually find one or two sentences to write on each of these cases, is then to take that information and do this with it. This is the next part of the lesson. All right? There are your cases. Look at those cases. Which ones limit governmental action? When you look at the cases that are in that section, which ones of those cases limit governmental action? Say that the government cannot do something. Government needs to stay out of here, or they can't use that evidence, or anything like that. Which case is on that list? Okay, Kilo, Cats, Map, right? Okay, so you've got these. Grow, Griswold, cats at Kilo. Government action is limited. Government access is limited. So the other ones expand governmental power. Now, when you create this list, even your least interested student may notice something that leaps out at you on this list. Where are expanded governmental powers expanded the most? Schools. In relation to minors. Government power is expanded and reinforced and upheld when dealing with minors in a public situation. Minors have very limited rights. If this doesn't go, we're doing nothing well. Okay? But yeah, we tend to take power away in a school environment and in a more public environment. Yeah, over in limited governmental action, those are all limits on adults, right? And all those take place. Grow, Griswold, home, Kilo in the home, cats inside the glass version of your home no longer exists. That is a good point. I had completely forgotten. You do have to show them the phone booth. And the whole point of that phone booth is what? Closing the door. I close the door so you can't hear me. There's actually a guy who runs around in Chicago. I don't know if you've ever heard of this guy. He calls himself the First and Fourth Amendment Project. He runs around and gets on public transportation and he has one of those long mics and a tape recorder, digital recorder, and he records one end of the phone conversation. And all he doesn't like invade your personal space. He just points that directional mic at you and sits there and will look right at you while you're talking on the phone and let you know, I'm recording your side of the phone conversation. And then when you yell at him and say it's a private conversation, he pulls out that confers unreasonable expectations of privacy and he hands him a card with a quote that says, sorry, it's not reasonable for you to expect that you can sit here and whine on your cell phone in a bus and not have the rest of us hear it. What are we supposed to do? Go, oh, I'm sorry. But the point here is to show them that there are limits placed. In which cases are new? It's a mixture, isn't it? It depends. It really depends on the situation, doesn't it? That's what we're, I guess, more than anything is what we're trying to show here. Is yeah, there was a movement towards protection, then there was movement away from protection and limitation, and then there was a movement that said, yeah, you know, maybe some of this stuff goes too far. Even like the warrant, okay, an invalid warrant, you can still gain it, but if the warrant was written incorrectly and then issued incorrectly, okay? If you did everything wrong with that warrant, you can't use it. If it's not your fault the warrant's bad, then you can't. Okay? But if everything about the warrant was bad, then they're going to throw it out. The DVD discussion question, not that we've already talked about. The devil was that? Apparently decided it wanted to go somewhere. Anyway, the DVD discussion question, let's see if I go back. Okay. What we're going to do now is watch the DVD. Think about this question. Remember, this is a question we're asking the kids, and we're asking them based on what's in this DVD.
One of the things that separates America from a dictatorship is the Fourth Amendment. Because in a dictatorship, the police agents are basically able to search anybody's home whenever they want to. Whenever they think that there's any suspicion at all, whenever they think it's a good idea, those homes are vulnerable to police searches.
The Fourth Amendment to the United States Constitution provides that government may not conduct a search or seizure of an individual. That means may not interfere with your privacy unless there is probable cause to believe that that particular individual has committed a crime or will commit a crime. This was a very important guarantee in light of the history of mass searches that were conducted by British officials, where they would just, go into places of business and homes and just conduct these pragmatic searches for evidence of crime. Our framers wisely decided that before government could interfere with your freedom of movement or your privacy, it had to have a particularized justification for doing so.
They divided the power between two separate branches of our government because they did not want the police to have the power all in one branch, where the police could decide among themselves when they thought it would be a good idea to raid a home or a business. By separating the power between two separate branches of our government, the founders thought that they were giving the police enough power to investigate crimes and apprehend criminals, but not so much power that it would lead to government harassment of innocent citizens.
Stand right there.
As a result of an arrest warrant and previous buys that were made here, we've now served a warrant and seize this apartment.
What the Fourth Amendment requires is that a search may not be undertaken unless there is probable cause. And probable cause in that context means a good reason to undertake the search. Now, it doesn't necessarily mean that it is more likely than not that evidence of a crime will be found in the search, but it does mean that a fair-minded person in the position of a police officer would have to have a good reason for thinking that there would be that kind of evidence.
With respect to arrests, we're talking about the power of government to deprive someone of their liberty, to take someone away from their family, to put handcuffs on them, and to put them in jail. With respect to search warrants, we're talking about the power to break down the front door of somebody's home and to potentially hold the people in the home at gunpoint while the police officers turn the place upside down looking for evidence of a crime. We don't want those powers unleashed on the basis of rumor, gossip, or simply the hunch of the local sheriff. And that's why the founders established probable cause. They established a higher threshold before the police are able to exercise those powers.
Although the police are bound by the Fourth Amendment, occasionally they do not follow the law and conduct searches without probable cause or search warrants. To help deter this, courts refuse to allow prosecutors to use such illegally seized evidence in court. It's called the exclusionary rule because any evidence seized in such an improper manner is excluded by the court.
We've had instances in this country where the exclusionary rule has not been in place. In the city of Cincinnati, for example, in 1959, the exclusionary rule was not in place, and the police only applied for a single search warrant during the entire year. So we know that when the exclusionary rule is not in place, the police do not bother applying for search warrant applications.
The downside of the exclusionary rule is that it's costly, but also inefficient. It's costly because it prevents the public and juries from knowing the whole truth. And of course, that is a very important cost that our system pays. The primary purpose of a criminal trial or of any trial is to bring out the truth. And when the system cannot do that, that is a significant disadvantage. It's also inefficient. The exclusionary rule is inefficient because it does not punish primarily the officer who did not comply with the Fourth Amendment. So perhaps a better way would be to impose a fine on the officer, but still allow the jury to see the evidence.
There will often be disagreement over what makes a search unreasonable, over how to deter some overzealous police without undermining the ability of all police to fight crime. That's understandable. At the heart of the Fourth Amendment and many other protections of the Bill of Rights lies one fundamental maintain order against your right, my right, the right of all citizens to personal liberty. I'm Tim O'Brien.
Question was? Technology. The question is right there. Should the exclusionary rule keep prosecutors from using evidence in court? Why or why not? Now, they read the essay, right? Read the essay. They've done the quick listing of what limits government, or what limits government action, what extends governmental power, okay? How are you going to approach having them answer this question? What can we do? Have a debate? Research. Okay, higher level, let's go ahead and research some questions. Let's have them take a look at it. Okay. Let's have them go out, go to the library, go to the media center, go online if you have access to it.
And they can use that.
They can use that in the debate. Okay. What area do we want to focus on? What do we want to have this question asked? Should they be allowed to, should the exclusionary rule keep prosecutors from using the evidence? I mean, it's evidence. The person committed the crime. We have the evidence that shows this person did it. We know we've got the right person, and they're going to walk. Is that okay? You don't care. Here's what
I think if you analyze the situation in Europe to some degree, most European countries, I think, punish police officers to allow the evidence to be admitted. Anybody know how that's worked out for them?
He wants to use international law.
Judges like Justice Kennedy.
He is.
Well, I think as they analyze it, that's one thing to consider.
Okay. Yeah, well, you know, there's at least 4 members of the court who would agree with you that you should use international law precedents. Yes.
I guess one of the things you haven't heard in this nor in the other presentation is what happens when that evidence really wasn't that person's evidence and it's been planted there because the police have that power because they do not have a warrant. Things were not followed correctly and it is now a different situation. We know that, what was it, 2% of the 2% are people who are let go out of 100, 2 out of every 100 who are let go when there's evidence that can't be admitted, but how many people are convicted with evidence that isn't theirs?
Good point. So we have a dispute over what, if you allow police expanded powers, does that allow for more abuse in cases such as planting evidence? You know, Dolly Knapp, I guarantee you, if the police could have, they would have planted evidence in that house because they were tired of her, okay? Yeah.
And I was thinking about what he just said and thinking about the reverse, using some paradigms of Latin American nations to the south of us, as far as their treatment of potential criminals.
Right. Okay, so you go to the more authoritarian regimes, look at how they handle things. Okay, the fact is that if they want you off the street, it's not very hard for them, right? Break down your door, walk in, put whatever they want in your house. Maybe it's in your house, but if it isn't there, create it, put you in jail, throw away the key.
And being more precise, if we take a look at Sao Paulo in Brazil, in terms of what's going on there with their youth population and the various tactics they use as far as cleaning the streets and kids when they're out late at night.
Right. Because they're afraid that it's creating an unsafe condition. Whether or not it is open debate, but what we're going to do is deny them the rights to assemble. We're not talking about minors here, we're talking about young adults that are doing it to young kids.
What was the penalty for officers? Did I hear him say a fine or
He
something?
said, why not put a fine? Why
Because
not
the normal
punish?
police force just chips in enough to cover the guy's fine, and they get the person they've been trying to nab for years, and everybody's...
But do we do anything? This is a good question. Do we do anything to police who violate this rule? No. I don't think, is there any law in the books now, Arthur, anywhere in the country that punishes the officers, or punishes the judges for putting out a bad warrant? There's no law that punishes the people who violate the Constitution. There's a law that protects you, okay? There's a law that protects your constitutional rights and your protection here, but there's no punishment for the person who perpetrates the violation. Yeah.
Seems like we're talking about two different things.
Okay.
One of, didn't get a search warrant and found something legitimate versus police officers who plant things
Right.
in order to benefit themselves.
Right.
So we're saying there's no law or prosecution of officers who would plant.
Well, if they can prove you planted it, yeah, you can be disciplined for manufacturing evidence. Okay. But let's just talk about this person violated the policy. Bad search, went in. You aren't guilty. I did it. That crack pipe and crack belonged to me. It's mine. But you had no business in my house. Should that police officer be prosecuted or fined or punished in some way? Yes.
Well, I mean, you're saying you're reprimanded by your department.
Right.
It's just like any, we mess up at our job,
Right.
it's illegal to mess up at your job.
Okay.
Reprimanded by your supervisor.
Okay. So you'd say internal review by the police department is no. And then if an officer is one of these folks who's continually involved in these kind of illegal searches, then perhaps it's time to put him on a desk somewhere and out of interaction with the public in those kind of areas.
Can I sue him in civil court?
Can I sue him for violation of my rights?
I mean,
Civil rights?
Yeah.
What harm came to me? I didn't go to jail. Oh, well, that's just my character. Can I sue him? I don't know. Has anybody ever sued over?
There are suits like this all the time. The question is what jury is going to find this?
Yeah. I mean, I can't remember hearing any holding where a police officer's been, or a police department on a search and seizure issue.
Yeah.
I mean, I've heard about where they announce you as a person of interest, and there's millions of dollars involved in these high-profile cases. Yes.
I think looking at it from a law enforcement standpoint too,
Yeah.
though, if you put in a law in place to punish police officers for potential violations of search warrants, then I think it has a chilling effect.
Okay.
Police officers' willingness to conduct a search.
Okay. So, and what would the people who are in favor of that benefit say, or that law say about that chilling effect?
That would actually have a reverse effect.
Well, they'd say that's a good thing. I don't want the police searching everywhere just because they think they should. I want them to be willing to put themselves on the line that what they're doing is right, instead of just acting on a hunch or a general idea that I may be involved in this. They should have to prove. They should have to meet the same standards I'm going to have to prove guilt on this thing. Okay? Next is here. Yes?
No, I'm just kind of thinking through. I mean, I don't think it matters whether the police officer, if he's guilty or not of mishandling the warrant. I mean, we're just looking at the law itself. So I don't think just because they screw up, that evidence should still be admissible. You know what I'm saying? So I think I see it as two different things.
Okay, so you're all seeing these different approaches. The key here is, as you think this through, you want your kids to understand this, right? You want them to have a debate, you want them to do some type of work with it. In some way, shape, or form, you want them to apply this information. You're struggling with it. How are your kids getting it? So how are you going to go about it? One way to go about it is the way we've gotten here, these case studies. I'd like you to go, and that's exactly where we are. You're right, there's 2 or 3 different questions going on here, aren't there? Okay? What are the limits on police power? How do we put those limits on police power? And what are my rights versus the rights of the public to be free from a scum like me who smoke crack in my apartment? Okay? What are the different, there's all sorts of things going on here, right? All sorts of different goods happening here. So let's look at page 122. Look at the case summary here. In 1999, a Baltimore County, Maryland police officer pulled over a Nissan Maxima for speeding at 3:16 a.m. Ooh, 3:16 a.m. speeding. And it's a Nissan. We all know what that means, don't we? No? Okay. The arresting officer saw a large roll of bills in the glove compartment. Okay. Searched the car with the owner's permission. 5 bags containing small amounts of crack cocaine were found behind the backseat armrest. The officer then threatened to arrest all 3 occupants of the car unless someone admitted ownership of the drugs and the money. Each refused to confess. He arrested all 3 2 hours after they arrived. The front seat passenger, Joseph Pringle, admitted the drugs and money were his. The officer released the driver and other passengers. Pringle was tried, convicted, and sentenced to 10 years in prison for possession of cocaine with intent to distribute. Why possession with intent to distribute? Huh? All that money in a big roll in the glove compartment and 5 bags. Okay? Maryland Court of Appeals overturns the conviction. State of Maryland brings the case to the court. Did the police violate Pringle's constitutional rights against unreasonable search and seizure? Okay? Just because he was in a car that contained illegal drugs. Arguments for Pringle. How did they violate his rights? Illegal search and seizure.
You could argue that when he was pulled over for was not selling, they didn't seem to selling drugs, it wasn't speeding.
The car was pulled over for speeding, right? Who was being arrested? The driver. Where was Pringle? The passenger seat, okay? Nothing Pringle did, nothing Pringle had done led to this arrest. So, at that point, okay, so Pringle wasn't even driving the car. The incident didn't necessarily create the situation for a search. What else?
They didn't ask his permission.
They didn't ask his permission, they asked the permission of who? The driver. Do we know if the driver owned the car? No, we don't. We're assuming the driver owned the car, right? They asked permission to drive the search car, driver gave permission. Didn't ask the other 2 people in the car, right? Okay. What else? Confession may have been coerced. How? Pressure on him. It's 3 o'clock or it's 5, 6, 15 in the morning when he finally says, yeah, it's mine, let these other 2 guys go. All right, and he confesses. Okay. So we got lots of things here. There's no evidence of money and drugs from Pringle and not the other occupants. How do we know that? Because nobody owned up to it. Whose is this? I don't know. Okay. There's no evidence of money and drugs for other people's occupants. This car owner's permission harmed Pringle. By the car owner, and we're going to assume here that the driver owned the car, that harms Pringle. By allowing that search, the owner of the car took away Pringle's reasonable beliefs. How about against Pringle, for the police? Why was this a good search? Car owner gave permission. If the car owner gives permission, I can search the material. I can search the car. What else? Found the drugs. Okay. Okay. What else? Before I found the drugs, what did I know? The money, where was it? Plain sight. Apparently the glove compartment was apparently open and that roll of dollar bills was in plain sight. So what? I got a big roll of cash in my car. Big deal. So what? What about that big roll of cash? Why is that such a big deal? In the context, it's 3:16 in the morning, you're speeding down the street, and you're 3 of you in the car, and I find this big wad of cash. My instincts as a police officer immediately go up. I don't think people usually run around at 3 in the morning with a large roll of bills in their car unless they're up to no good. Yeah.
Remember, in some cases, I don't remember the name of it, but the whole concept of what constitutes consent also is in question. Is that something that could have been used or was used where people are reluctant to say no to police officers, so really consent doesn't really mean consent?
Right, we can do that in terms of is the consent legitimate. But in this case, we're going to assume the consent's legitimate because the car owner doesn't say, oh, I was forced to do this. The car owner doesn't necessarily just okay, I can search my car. Okay, did he know that money and drugs belong to somebody in the car? Chances are pretty good the answer to that one is yes. Somebody in that car owns this money and drugs, right?
And it's in front of the Pringle, right? The money is.
The money in the glove box, yeah, if this is a normal car, the glove box is right in front of the frame, right? And then the crack is in the back armrest, so apparently he threw it to the guy in the back and shoved it in the armrest or whatever. Okay, and then there's one more thing. He confessed. He said he did it. Why should I throw this out? Okay? It's a good question. So let's ask you. You gonna allow the evidence? This is 5-4, but it's 54, so what we have here is, I guess, 28, 26 would be the answer. We gonna allow the evidence? Ready to run? 87% of you are gonna allow it. Mr. Pringle's going away for 10 years. He deserves every single hour of every single day. So what the court said, you're right, this is entirely reasonable, okay? There is no doubt in a reasonable person's mind that once you have permission to search this car, when you find this money and this cocaine in this car, it's perfectly reasonable to assume somebody in that car owns it, okay? And they had knowledge of and exercised control over the cocaine. Okay, there's a probable cause of committing a crime, either solely or jointly. Chances are, maybe Pringle decided to take the fall for his friends. Maybe all three of them were out doing the sales, and Pringle said, "Oh, I'll take the hit." Okay. In any way, shape, or form, this isn't eminently reasonable to the police. Okay. USB Banks, it's the one before this.
Can I raise a question?
Yes.
This would be a fun case to say, what if this was 1967?
Sure. Absolutely. And again, use your knowledge, use how, different time frames, okay? This is 1999. How about this is 2001? September 12, 2001, and he's speeding through downtown Washington, D.C. Okay? And they all look to be of Middle Eastern descent. Okay? Is that going to change how people are going to look at the case? Yeah, I can come up with a case where you go, absolutely not, you can't do that. And then I make it on the day after the Pentagon is still smoking in the distance. Oh, well, absolutely, go ahead. It depends. A lot of it depends on the context, doesn't it? The 60, it's perfect. Go back to just before that. Okay? How about Banks? I love Banks. This is one of my favorite cases. They show up at his Vegas apartment at 2 p.m., warrant to search for cocaine. They call out police search warrant, wrap hard on the front door, 15 to 20 seconds. Police at the back door here say, I heard him ask for it. Okay? Break down the door. He'd been in the shower, said he heard nothing until the crash of the door, which brought him soapy and dripping wet to see police in his living room. Search the apartment, found crack cocaine, weapons, other evidence of drug dealing. He's arrested. District Court denies the motion to suppress. Banks pleads guilty and says he would challenge the seizure in his appeal. Okay? For Banks. For Banks. Nobody wants to help the drug dealer. Thank you so much. There's more money in being a defense attorney than a prosecutor, so let's think that way as lawyers, okay? And this guy obviously has a pretty good dealership. He's got weapons, he's got coke, he's got cash. He can pay me. Yes?
Well, just what's the reasonable expectation of the amount of time?
Okay. Yeah, 15 or 20 seconds, is that reasonable, right? Okay. There's much else going on. I'm in the shower. I'm in the shower. I can't hear the knock. And is 15 or 20 seconds reasonable? He says no. How about for the police? Yes. Yeah, I'm hearing running water, perhaps. All right? And I'm thinking, I'm coming looking for crack cocaine. What happens to crack cocaine when it's put in water? It's gone. Okay? I'm thinking destruction of evidence. What else?
Had a warrant.
Had a warrant. I knocked and announced, right? Yeah. I'm worried about, it's 2 o'clock in the afternoon. We didn't even put that one up there. This isn't, 3 a.m. or whatever. It's 2 p.m. I know he's home. Reasonability. Do I expect him to be taking a shower at 2 p.m.? No. I hear water running. I know this guy's a drug dealer. What am I thinking? Destruction of evidence. I've got a warrant. I'm allowed to enter. And the other one is, on that warrant is, I know this guy has weapons. Okay, so if I wait longer than 30 seconds and the next sound I hear from inside is a bolt being thrown on a semi-automatic machine gun with the answer, come in, that's really not smart on my part as a guy. All right, so, you gonna allow the evidence? All these fine public service. Let's see, you know, all the others? Well, there's a few of you out there who are still thinking that this isn't a good idea. This is no knock. Reasonable suspicion and announcing the presence would allow destruction of evidence. 15 to 20 seconds, they could fairly suspect that the cocaine would be gone. Okay, we waited 15 seconds. If I wait any longer, the evidence is going to be gone. I can come in now. Okay? Illinois v. MacArthur, 3 p.m. This is a great one. Tara MacArthur to the trailer she shares with her husband. They're in a separation. She's making sure she's got the police with her to protect her from her husband. As she comes out, she says, "Chuck slid some dope under the sofa." Okay? Chuck slid some dope under the sofa. When Assistant Chief Love told Charles what Tara said and asked if he could search, Charles said no. He sends the other officer and Tara to obtain a warrant. Charles, out on the porch, was told by the Assistant Chief he couldn't re-enter the trailer without an officer. He went back in 2 or 3 times. Stood in the corner to observe. Returned at 5 p.m. They arrested for smoking paraphernalia and a small amount of marijuana. Unlawfully not allowed him to re-enter his home and destroy his materials. Okay? If he'd had the chance, I would have destroyed the marijuana. Okay? It goes to court. For MacArthur, why should they suppress this evidence and he should be allowed, this should all be kept out of the court? Hearsay. Huh? No warrant. Okay? MacArthur says, I'm divorcing this woman and she just told you there's dope in the apartment or in the trailer. Is it reasonable to believe she's lying? So this whole thing is based on the premise of a woman scorned. His answer is, I'm going through all this. Whether or not I really have it doesn't matter here. You're getting a warrant based on a false premise. I've got a woman who brought police to the house because she thought I was going to hit her when she left. Okay? And she's found a way to get back at me. Yes? No. Isn't that the current rule? Both? Not just one, it has to be both? Because that was another case. And then the officer has the right, well, but if both of them are available, one says yes, one says no, the answer is no. Yes?
Could it still be invasion of privacy if the officers there watching in the house?
That's what he's saying. Reasonable expectations. You don't have a warrant. You don't have any reason to have to come into my house. I want to go back in my house. You can't go in unless I watch you. So the officer's standing there watching him in his house. Violating my privacy rights. Okay? Dennis MacArthur's wife knew there were drugs and knew her husband was using. Drugs would likely have been destroyed, which he says they were, and he was only kept in the home for a short time. Only about 2 hours, and he was allowed back in. He just had to be supervised. Okay? So, you gonna allow it? they say no. Why? What is it that bothers you about this? By the way, they said yes, allow it. The restriction was reasonable and lawful, okay? The police had probable cause. What's the probable cause? The wife walked out and said, Chuck slid some dope under the couch. Probable cause. Chuck slid some dope under the couch, okay? Good reason to fear that unless restrained he'd destroy the drugs. What's the good reason? He said he would have. That's good enough for me as a judge. He said he would have, okay? Third, the police made reasonable efforts to reconcile their enforcement with demands of personal privacy. They did not follow him into the bathroom. They did not follow him down the hall. They stood at the doorway and let him have the run. And if you've ever been in a trailer, you know they've got that one long side. You get the living room, the kitchen, the side hall, the bathroom, and the bedroom. They let him go into the bathroom, let him go into the bedroom, let him close the doors, no problem. He just could not, the area that they were worried about, they wanted to watch him around the couch. So if he had had, a few ounces stuck in the bathroom, he could have gone in, poured them all down the toilet, flushed it, and they would have gotten away with it. So they say it's for the police. Okay? So now we're out of time. I want to show you the next section. So now you've applied this through scenarios. The next section would be to show the kids, like you're talking about, how hard is it to write a good search warrant? How hard is it? Okay? Choose one of those cases and try to write a search warrant for it. Try to write a search warrant that meets every aspect of what you know a search warrant has to do. Describe the houses, places, and persons to be searched. Describe what it is you're looking for. Make it clear enough so that if you find something, it's constitutional. Okay? As a police officer, fill out that search warrant. The other side of the group, and you can do this actually facing each other like this at tables, hand it across. Now that's the judge. Does it meet the requirements for a lawful search? And you're only using those short scenarios, right? Those little short scenarios. Just apply this thing. Show the kids in a very simple way, because there's a lot more to writing a good search warrant than this. But show them, this is how it actually works. The police write out the warrant, okay? Or the DA writes out the warrant, writes the whole thing down, says exactly what it is they're looking for, takes it to the judge signs off on it. Now, if you look at that as a judge in the case and it's being challenged, is the warrant valid?
I could go back to the question that we started with the section, whether or not a police officer should be charged for an illegal search. Since on these three cases, we come to a 100% conclusion whether or not the person was right or wrong.
Yep.
Isn't that an unfair standard to hold a police officer, since a judge would have been in the same position as us, and each one of these would have a different answer? We both came on either side. How's the police officer supposed to know?
What a great way to finish the lesson.
If the judge is going to say, yes, that's legal, or no, it's not.
What a great way to finish the lesson. You got all these variables in play. The police officer's making a call right there on the scene based on his or her knowledge, right? Can we hold them to a standard that could cause them to be, even in good faith execution of their job, should we hold them to a standard that could cause them to be either A, fined, or B, imprisoned for trying to act in the best interest of their community? It's a great way to wrap it up. I like it. Okay. All right, do we need a break before we go into the death penalty, or do you just want to find out about death while you're sitting there? 5 minutes?